25, 20, 20.
ওই তো ম্যাডাম আছেন,
Number 25.
ওই তো
20.
কলার, ওনাকে ডাকুন না। নাম দিয়েছে, ওই তো পিটিশনার আলমারির পাশে দাঁড়িয়ে আছে।
Number 24. Item number 25 has it been called on?
Item number 20 has not been called. We are 25. The 20 application কি দুটোর সময় হবে?
Extension of
Sir,
interim order today. 2 p.m. Extension of interim order.
হ্যাঁ
2 p.m.
25. 25, not today.
But this is my application, this is my affidavit of service affected. Can you see?
ঠিক
This is regarding my lord unauthorized construction blocking my way to egress and ingress, my lord, and to that effect, my lord, Panchayat made an inspection, and lordship will find page number 48 and 49 that the Panchayat has decided, has directed to stop work and to, my lord, reinstate the, my lord, the earlier position, since it has not made in accordance without making any sanction plan, without obtaining any sanction plan. But in spite of that, that has been going on, my lord. Now, my lord, the water is stagnant in my lord room, and my lord, my way to egress and ingress has been seriously affected. So, mandate direction be given, my lord, to remove that unauthorized construction. But this is my prayer, my lord. In terms of my representation, that 18/7/2024, that is page 47, and thereafter more representation is also there. And the photographs is page 58, lordship will, my lord, peruse. পঞ্চায়েতে দেখো 49 পঞ্চায়েত নিজে ডিরেকশন দিয়েছে, তার কনসিডার কেন পঞ্চায়েত নিজে ডিরেকশন দিচ্ছে, তারপরে তো রিমুভ করছে না, আমি তো আটকে গেছি। করে দাও। Page 14 and 49 is the Panchayat Authorization. 48, 48A and 49. Panchayat also hold that. And Mala 58 is the one of the photographs. Panchayat has to execute his own order by removing the unauthorized.
Done.
You are for?
My learned friends,
I am for the plea.
I am for the Hubli Jila Parishad.
1, 2, 3. In that case, Disbursement number 4.
Respondent number 4.
What is your submission?
My lord, Jila Parishad has no role to play.
But already, Pradhan already passed an order.
that has to be executed.
There is a page 48 and
48A and 49
48K
and 49.
and 49. That should be executed by the owner. Hiram now,
Together,
I will not challenge.
together. আসুন। Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities, particularly respondent number 6 and 8, to remove the unauthorized construction by considering the representation of the petitioner dated 18 July 2024. 18 July 2024.
Representation number 187 is 47.
Annexure P3. ठीक है? The petitioner contains that the petitioner and respondent numbers 11 and 12 are the joint owners in respect of property measuring 8 decimals together with 500 square feet tiled shade structure standing comprised within LR and RS plot number 4694, LR, LR Khotian number 2001 by 1, jail number 57, Mouja Jonai, PS, and police station Chonditola. Hooghly, this is?
My district Hooghly.
Hooghly, district Hooghly. The petitioner transferred a demarcated portion of land measuring 2.44 decimals in this said property in favor of respondent number 11 in the year 2015. The respondent number 11 and 12, without obtaining sanction plan from the concerned Gram Panchayat, has erected unauthorized cemented slope blocking the common passage of the petitioner. Due to such construction, there is water logging during rainy season in the land of the petitioner. The petitioner made a representation on 18th July 2024. The local Gram Panchayat issued a stop work notice. However, thereafter, no such steps has been taken for removal of the unauthorized construction. Hence this writ petition. Learned advocate for the petitioner submits that specific direction be issued upon the local Gram Pradhan of Jonai, respondent number 8 to take immediate steps for removal of the unauthorized construction. উনি হচ্ছেন জনাই গ্রাম পঞ্চায়েত। Learned advocate for the state also, state as well as Jila Parishad. Hooghly Jila Parishad respond number. Hello? You are respond number
4.
4. State also submit the matter be relegated to the respond number 8. Learned advocate representing respond number 4 submits that the Jila Parishad has no role to play. Upon hearing the learned advocates for the despite service, none appears on behalf of the Pradhan. Respond number 8, Pradhan Jonai Gram Panchayat and private respondent number 11 and 12. Upon hearing the learned advocate for the petitioner, the Pradhan. Respond number 8 is directed to consider the representation of the petitioner dated 18 July 2024, adopting the following procedure. Cause an inquiry in presence, hearing yes, and take steps in accordance with section 23. Within a period of 2 months from date of communication.
Mother, may I bring,
It is made clear that we have not gone into the merits.
Mother, may I bring one in, my lord, may I bring one indulgence, Lord? My lord, page 48 says, my lord, Panchayat has completed his inquiry and passed a decision, but that has to be implemented. I'm grateful.
Lordship, may I seek your indulgence? Your Lordship, item number 13, I could not appear since I was in leg in another court. Only a service direction could be given to the private victim lady, so that on the next day we could.
But order has been passed. Who is for the petitioner?
13. No service has been made yet. So a service to the victim is required. Since the matter will again be taken up, before that time, if you could make it the effective service.
6th August. K নিয়েছে 13টা। State के direction दिए देगा।
Yes, Lordship. State may be directed.
13 बोलो तो state is directed to cause service. যদি না থাকে। Okay. দাওয়া আছে মনে হয়। ডিরেকশনটা দাওয়াই আছে। তো স্টেটের অ্যাপিয়ারেন্সটা নোট করে নাও। It will be done.
Grateful.
Item number 27.
I appeal for the petitioner, my lord. Today,
Who is nobody?
there's nobody is appearing. This is with respect to,
Tomorrow.
my lord, unauthorized construction made by the private respondent. The respondents had been intimated several occasions, nothing else.
You are the owner.
I am the owner of the land.
Construction has been undertaken adjacent land.
It is the land right in front, between the road and my land. The private respondent is making a construction there. It is still in the preliminary stage. Lordship will see the photographs at 31. Only the pillars had been constructed. We had intimated the authorities on several occasions. And in fact, at page 41, the Pradhan is writing to the PWD to take action against the illegal or unauthorized construction.
It is over the PWD land.
It is on the PWD land. But no, obviously for this reason, they have not obtained any, could not obtain any sanction plan, cannot.
Tomorrow.
Tomorrow. I'm grateful.
Number 28.
I'm for the petitioner, my lord.
You have not today.
Lord, this is my epidemical service.
Tomorrow.
Lordship,
Tomorrow.
আজকে দেবে আজকে 29
You need. নিয়ে কি করবো? It নেই, কেউ নেই। Tomorrow.
Thirty, 31,
For the petition.
Tomorrow what to do? Tomorrow.
32,
And for the petition. 32.
You are for?
করবেন? 32.
32,
32. হ্যাঁ, আমি পিটিশন।
কে appear করছে?
State is there in 32.
No, my lord.
Tomorrow.
33 also I'm for the petition. I'm for the
33.
petitioner.
34, my lord, I am for the petitioner.
32. Where were you, sir? Madam?
I was seeing the brief.
32, my lord, I'm for the petitioner, my lord. This is my affidavit of service, my lord. This matter is relating to the payment of dues, my lord. The petitioner participated in a tender process, my lord, floated.
Service is complete.
Yes, my lord.
State is the party only.
Yes, my lord. Only the state is the party, my lord. There was a tender notice, my lord, was floated, my lord, by the authority concerned, my lord, and thereafter, my lord, work order issued by the petitioner was the highest bidder, and my lord, the work order was issued in favor of the petitioner, my lord.
What
Thereafter,
is that?
yes, my lord, work order. My lord, the page number 12 is the supply order, my lord.
Work order.
This is the supply order, and my lord, work order is
Same.
my lord, more or less.
So you have to supply certain materials. You have supplied the materials.
Yes, sir, my lord, absolutely, my lord. Thereafter, my lord, I have thereafter, my lord, no, I have issued, my lord, the bill, my lord, to the authority, my lord, but till date, my lord, no bill has been payment,
is
my lord, done, my lord.
Receipt of the supply that you have supplied.
My lord. Supply order, my lord.
No, supply order is there that you have supplied the materials. They have given any endorsement
my
that
lord,
they
yes,
have
my lord.
received the materials that you have supplied.
Yes.
Where is that? Total 5 numbers of consideration schemes.
My lord, the page number 19, my lord. It is the first paragraph, my lord. The last line is, my lord, converging the department while payment from MGNR EGS have already been done, my lord. Already been done, my lord. That is the reason, my lord, if I am not supplied the materials, my lord, the payment will not be in favor of the petitioner.
So which one? 2 lakhs? So what is the amount?
2 lakhs, my lord. Till date, my lord, no payment has been received, my lord, by the petitioner, my lord. My lord, may I submit, my lord, one order, my lord? Coordinate bench has given this order, my lord, kindly for your perusal, my lord. Not
Representations 4722.
in this matter also, my lord, the payment was not done, my lord. My lord, the coordinate bench has directed this order, my lord.
Yes.
Lordship, may I be permitted to submit a report?
What is in the report?
The amount was to be paid by the Manrega and ICDS. The Manrega has paid the amount 4,99,854, and the rest amount of 2 lakh was to be paid by ICDS. But it could not be paid due to non-availability of funds, Lordship.
It's the same situation, my lord. In every matter,
Who will
state
will-
authorities are saying this, my lord.
who will disburse the amount? Which authority? Block development?
ICDS.
PTO, my lord.
PD.
PDO. Ask him. Affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the writ petitioner seeks for direction upon the respondent authorities, particularly the respondent number 5, Block Development Officer and Program Officer under MG NREGA for disbursement of an amount of rupees 2 lakhs. Outstanding amount rupees 2 lakhs. And the petitioner contends that he participated in a bid notice published by the Office of Block Development Officer Horiampur or Horirampur.
Yes, my lord. Horirampur.
Horirampur,
Look in Dinajpur.
Dakhin Dinajpur. And he was granted the supply order with a memo number P160/HRP dated 12th December 2018 for construction of AWC under the MGNREGA in the area Shasha-Roman 1 in Srishi Gram Panchayat. So the total amount was 6,99,000,
Yes, my lord.
out of which 4,99,000 you have received.
Before filing of the writ petition, my lord.
You have received.
Yes, my lord. That
Okay. No, you have received
no, my
499.
lord. Though that instruction is not with me, my lord. That I have to take instruction.
2 lakhs is outstanding.
2 lakh is outside.
An amount of rupees 2 lakhs is outstanding.
Paid us.
Outstanding.
That's what.
Learned advocate for the petitioners submits that necessary direction be issued upon respond number 5, dear the Block Development Officer and Program Officer Manrega for disbursement of the outstanding amount of rupees 2 lakhs. Learned advocate for the state submits that due to non-availability of fund, the said amount could not be disbursed. He files report of the Block Development of Horirampur, Dakhin Dinajpur, dated 21st April 2025, which is taken on record. Upon perusal of the report filed by the state, it is found that the outstanding amount of rupees 2 lakhs is not disputed. Accordingly, respond number 5 is directed to take steps for disbursement of the amount of rupees 2 lakhs in favor of the petitioner within a period of 4 weeks from date of communication of this order with the aforesaid observance disposed of.
My lord, kindly do not dispose of, otherwise they will not pay, my lord.
I will take you. Now,
Keep the break.
are you going to state আছে?
Item 33, my lord, same, my lord. Same order may be passed.
33, but state is there. Nobody for the state. Come tomorrow.
Not today.
Not today.
5th April.
Well, I'm for the petitioner. Well, this is unauthorized construction in Panchayat area. Affidavit of service.
You are representing all the private respondents. 7, 8, 9.
Yeah, my lord, I have filed affidavit of service, my lord.
Affidavit of service.
So, Lordship, kindly see, my lord. Annexure P1, page 22. So, this is my representation, my lord. A demolition of illegal construction.
No, the private respondents are the co-sharers.
Yes,
Co-sharers or
yes, sir.
adjacent.
He has purchased. Year 2024, thereafter conversion has been made. Sanction plan has been given, which has been annexed.
Your sanction plan, how?
Not for information under RTI Act, video has written. Will kindly see page 25 once, Milord. And one civil suit is also pending in the civil court, also directed not to disturb the construction work of the private respondent. That is also there. I shall show to your lordship.
No, my lord, sanction plan has been planned.
Kindly see first page 25 of the writ petition.
My lord, my case is that, my lord, sanction plan has been obtained fraudulently, my lord.
Okay.
Page 25, yes.
Fine.
What is there? Schedule of information required. The Kumar has got in sanction plan. Das has got sanction building plan. What is the disputed plot is?
588.
580. Sanction number is
588.
But that is joint property, my lord.
Ika Ghosh. Now the construction.
That is joint property, my lord. No demarcated has been made, my lord.
Construction over 588 is the concern in this writ petition. Huh? Okay. So there is a sanction plan. Somadas is respond number 8. Soma is not a party here. 7. 7, yes. Where is the order of injunction? Depending on your listing from condition, listing person.
Annex of writing.
So you are the plaintiff.
My lord, here plaintiff is my lord. My lord, Kaushik Ghosh. That is private respondent
8.
8.
And Soma is the.
Soma respondent number.
How Soma and Kaushik are related?
Soma respondent number 7. 8 sold to respondent 7.
Lord,
24.
where joint property sold to, my lord, private respondent.
Subject matter of the my lord, civil code, my lord.
No, my lord, how, my lord, my lord,
As regards to the
that is my challenge, my lord. My lord, how Panchayat, my lord,
which has
approved the plan.
given in terms of the my lord, sell deed, my lord. And civil court has granted me leave, my lord. They have a
You don't
right.
say me. Me means Kaushik or Soma.
Shoma.
Soma.
Huh.
Soma is a party in the suit.
Yes.
Soma has filed the suit.
No, my lord. Kaushik fight.
Baba. Yes, Soma has filed the
Fight against my lord Keka and others. Lord,
It is Soma.
I am trying to my lord get rid of the planes, my lord.
But here it is written Soma Das in the top of the order.
Uma Das.
The order you have handed over, it is Soma Das versus
Title suit number
title suit 72.
72.
Yes.
There are three court. Kindly check.
72 is the suit filed by Soma.
The 157. One suit filed by Keka and Sifra, that is title suit 462, was a self-same court, where Kaushik Ghosh, respondent number 8 is below defendant number 1. And in another suit,
72 filed by whom?
No, my lordship, kindly see paragraph 5 of the writ petition.
I have to check, my lord.
Lordship, kindly see paragraph 5 of the writ petition, my lord, how, my lord, the property was devolved upon the, my lord, petitioner.
Civil court. We are not with the title.
And my lord, I have twofold submission, my lord. The plot under reference upon which, my lord, plan was approved by the Panchayat, my lord, that is, my lord, joint property. My lord, several proceedings is pending before the learned civil court, my lord. My lord, let Panchayat file a report, my lord, how they have approved sanction, my lord. My lord, paragraph number 8, my lord. My lord, illegal construction was being carried out upon the plot of land which is undivided in nature. And my lord, your petitioner is the owner of the property, my lord. Paragraph 8, I have stated, my lord.
In title suit 72 of 2025, my lord, filed by Soma Das, when my lord, disturbance took place, my lord, in between the plots, my lord, she filed this title suit praying for declaration and permanent injunction.
Unauthorized construction is undertaken by private respondent number 7. This is the contention.
This is allegation. And in the suit filed by my lord Soma Das, this order has been passed by the learned court below. And more so, my lord, in terms of the my lord, there, my lord, RTI, my lord, the BDO has categorically stated that the construction is going on in terms of the my lord sanction plan.
Ashwin, affidavit service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner.
And one more thing, excuse me, my lord. As of date, my lord, I am not started any construction. Even if, my lord, we have a sanction plan, my lord. As of date, we have not started any construction.
No, my lord, let's state, my lord, submit a report, my lord.
What is your submission?
Kindly
Not report. Chalo. The petitioner seeks direction upon the respondent authorities to for demolition of illegal or unauthorized construction undertaken by respondent number 7, private respondent number 7, within plot number comprise within plot number
Plot number 588.
RS and LR dag number 588 Mouja Paira Gacha jail number 55 under police station Chunditala district Hubli. Learned advocate for the petitioner submits that the private respondent number 7 has undertaken illegal unauthorized construction over the property in question.
Which is the, she is the co-owner, my lord.
Huh?
My lord, the plot under reference upon which the, my lord, Panchayat has approved a sanctioned plan, my lord, that is, my lord, undivided property, and petitioner is the co-owner of the property.
Property over the joint property without obtaining requisite sanction plan. The representation was submitted by the petitioner before the BLRO you have submitted, not to the Pradhan. Which authority you have submitted the?
Well, actually, my lord, the BDO, my lord, had approved the plan, my lord, sanctioned the plan, BDO.
There is no representation.
No. After getting the report through RTI, thereafter no representations.
As, my lord, construction is going on, my lord, we have no other time, my lord.
He seeks for specific direction upon the Pradhan respondent number of Pradhana party. 5. Pradhan Tenditala Gram Panchayat.
The Pradhan and also, my lord, BDO, my lord.
Is construction. আচ্ছা পিডিও হচ্ছে 4 and 5 করে দাও 4 হচ্ছে ব্লক ডেমোলিশন নেই learned advocate for
3, 4 and 5, my lord. He is the sanctioning authority, my lord.
No, 3, 4 and 5. Learned advocate represent private respondents submits that Soma Das, respondent number 7, Soma Das, has purchased a portion of the property from Kaushik Ghosh and has raised construction by way of a sanctioned building plan.
May I hand over the
respondent number 7 has filed a suit being titled suit number 72 of 2025 wherein order of injunction has been passed restraining defendant from causing disturbance to the work of construction undertaken. The entire dispute is civil in nature. He seeks for dismissal of the writ petition.
My lord, I have obtained, my lord, that, my lord, sanction plan has been obtained fraudulently, my lord. That is my case. Upon the joint property, Soma Das is not a party to the original partition suit. My lord,
72.
My lord, Soma Das is not a party to the original partition suit.
For the state.
My lord, one of the co-sharer, my lord, he, my lord, illegally sold the property, his share of property to, my lord, respondent number 7, my lord.
He files a copy of the opponent, private respondent. He files a copy of the order passed in title suit number 72 of 2025 by Civil Judge Unit Division 3rd Court, Sirampur, Hooghly. Upon going through the aforesaid order, in title suit number 72 of 2025 filed by respondent number 7, following order has been passed. A order taken the court corridor. There is upon bare reading of the aforesaid order, it is found that there is a specific direction upon the defendants not to cause obstruction to the construction work undertaken by the plaintiff over the suit property. Considering the above, this court finds that the dispute between the parties is private and civil in nature. Accordingly, the petition is not maintainable and is liable to be dismissed. The petition being number WPA 5493 of 2025 is dismissed accordingly. Next. এই তুমি না একটা লিস্ট করবে যে তুমি petition নিচ্ছ আর কোনগুলো তুমি রিটার্ন পাচ্ছ। কোনটা অসুবিধা হবে? কি চাই? কোনটা? চলো বাবা আবার পেমেন্টে যাবো? কি আছে এটা? বেশি বেশি দাম নিতে হবে একটু বেশি নয়। এটা একটু বলতে হবে যে এই কাজটা আমার। আচ্ছা বাড়িতে যখন তুমি বাজার করতে যাবে মাছটা কিনতে যাবে দেখে নাও তো পাতা নাও কি না দেখে নাও 164 কেটে দিলাম এটাকে আমাকে একটু এই বাবা এটাকে বার করে দিয়ে আমাকে দিয়ে দাও। শেষ হয়েছে 4 item number 4
Lordship. Lordship, and for the petitioner, Lordship, this petitioner is in custody for 375 days. Charge has not yet been framed, Lordship. The allegation is that this petitioner has eloped with the minor victim girl, Lordship. Lordship, may I?
is for the de facto complaint.
De facto is the last occasion.
Present in person, she want to engage a lawyer.
She was present.
Today
She was present physically. I have asked him whether she is ready or not on the ground of that. On that score that she will appoint an advocate, my lord. The matter was adjourned through legal aid. But thereafter, my lord, he has not
In view
taken
of the
any step
inter-matter
for
and
appointment of an
complicated-
advocate through the legal aid.
response to the opposition members agreement to the compliance report. Really?
What is the 164?
One Mr. Obhinav Rokshit has been appointed.
Then my lord, today is not to personally adverse or
Mr. Mukherjee, then tomorrow.
Then on Monday.
On the joint prayers of the parties, place this matter on 4th August. Little rough.
হ্যাঁ স্টিপ সরিয়ে দিচ্ছি যাবে
For
the petitioner, my lord. I'm led by Mr. Chatterjee, my lord, Aniruddha Chatterjee.
find out your other side, otherwise how can the matter be taken up?
Well, I was just other side নেই মানে একটাই হচ্ছে যে আদার না একটাই জিনিস যেটা কন্টেম্পটে ওরা যেটা করেছে সেখানে ওরা নিজেরাই যে বলছে ডিস্ট্রিক্ট ইঞ্জিনিয়ারের পাওয়ার নেই সেটা নিয়ে কন্টেম্পট কোর্ট ইজ লুকিং ইনটু ইন দ্য মিন টাইম এই ডেমোলিশনটা স্টিল
demolition. The problem, my friend is right. The problem with demolition is the order which is under challenge before election. Now, the person who has passed the order doesn't have the power to pass the order of demolition, and they have admitted that. Have a look at this order. By taking advantage of Lord,
who has authorized district engineer.
the Bela Parishad, Lord, Mr. Bhattacharjee was appearing. He himself has produced, Lord, the records. Will produce the records of the case and in particular as to who authorized the district engineer to decide the issue subsequent to our order dated February 10, 2025.
এটা ডিস্ট্রিক্ট ইঞ্জিনিয়ার পাস করে কিভাবে?
And the district engineer, my lord, is the gentleman who has passed the order because he has no powers to pass the order.
And what is the subsequent orders passed in this CPAN?
রেকর্ড অন
The records have been called for and affidavits have been called for. Thereafter, my lord, there hasn't been any other.
Will it be correct to decide something in this
English
repetition
check
until
করো।
and
That
unless?
is why, my lord, the demolition needs to be still.
অর্ডারটা স্টে করে দাও।
This can also be agitated
The
before.
contempt court can't do that. It can't go beyond its order. My lord, before your lordship, my lord, it is up to. What I am on, my lord, on the face of it, the district engineer, they are admitting has no powers to pass this order. So this order, my lord, is basically non-est in the eye of law. And it's straight law. There is nothing, my lord, I need to show your lordship.
160A.
Absolutely. So there's no reason for, my lord, the order to be sustained at all. And
Okay.
problem is, my lord, that the authorities, because they are hell-bent upon to, my lord, to demolish my premises. It's a premises, I'll show your lordship, my lord, which is built because the government wanted me to build. It's a market area. What the private respondents were not given, my lord, the stalls. They filed the writ petition and said that there is it's built on a doba. And I will show your lordship, my lord, that doba is on one side. The other side, a road has been built and the nature and character has changed. And for that, a proceeding is pending.
সেটা ডিসাইড করে
এখানে কিছু লেখেই নেই তো।
না
Kindly stays the
That is-
demolition for the moment and then we'll come back, Lord, whenever your lordship.
Tomorrow.
Wait, we'll not
Come with
at the top tomorrow.
There were two. Huh?
Fairly at the top tomorrow.
This position will be retained. এটা কালকে এই পজিশনে রেখে দিন। ঠিক আছে।
Great.
And the orders passed in the appeal in MAT.
দ্যাট ইজ অ্যানেক্স দ্যাট ইজ অ্যানেক্স
It's all there, my lord, before you.
অর্ডার হাইকোর্টের অর্ডার পেজ 74
It's all there.
All have been.
I beg to appear, my lord, on behalf of the petitioner. So Chakraborty was there, my lord, I'm told. Oh, Dada.
Lordship, Mr. Supratim Dhar is appearing for the Panchayat. I am praying for 2 p.m. Kindly fix it at 2 p.m. Lordship.
2 p.m.
2 p.m.
2 p.m., my lord. 2 p.m., my lord, I have some difficulty today, my lord. Then may I
Make it short passover for 5 minutes or 10 minutes.
10 minutes.
or we can come back tomorrow, my lord, subject to my lord's kind convenience then.
No,
Tomorrow.
today it will be better.
Very.
Make it short passover. Mr. Chakraborty there.
Passover.
Main to-
Opposition has been filed.
I'm sorry, my lord.
Right? The opposition has been filed.
No, my lord, I will be asking for, my lord, an immediate interim protection.
Passover.
Grateful.
That 57, I beg to appear for the petitioner, my lord. But it's, my lord, assailing an order of demolition. In the meantime, my lord, during the pendency of the petition, my lord, the subdivisional officer have passed a comprehensive order of demolition, which, my lord, I intend to file a supplementary affidavit. If your lordship so grants me leave, may I file a supplementary affidavit enclosing the order of demolition passed by the subdivisional officer. I have already served this copy to my learned. Sure.
Lord, there's one problem. Tomorrow, my lord, there's an SLP in Delhi, my lord, I will be in Delhi. If it's on Monday, my lord, if it comes.
তাহলে 35 টাকে মানডে থেকে করো।
So grateful.
Copy these.
Mr. Chatterjee, do one thing, intimate the other side that it will be coming up on Monday.
Supplementary then? Oh, private respondent. এটা দিয়ে অর্ডারটা অর্ডারটা যেটা দিয়েছে my lord, what happened, my lord, before I will
Wait. Your order has been annexed.
my lord, an order, my lord, passed by the he has been annexed. My lord, this is an order which is at page 9, that was initially assailed before your lordship. Thereafter, my lord, the order of demolition was passed by the subdivisional officer, which, my lord, I intend to use a supplementary affidavit order of answer. And before
Deciding order dated such and such issued by the Pradhan.
lordship kindly comes to page 83.
Or the prayers are to be changed because
My lord,
if you want to have the cancellation of that order, this prayer has to be made. It is not by way of supplementary affidavit or the prayers.
yes, my lord, that is absolutely.
Withdraw this writ petition if you intend to challenge that order.
Now, I tell your lordship, the sum and substance of my challenge is a demolition order passed in connection with a structure which exists for last 44 years, which
No, no,
exists for last.
This you have challenged the order of the Pradhan. Now,
Pradhan.
Pradhan has referred it to the SDO. Probably
My
SDO has passed the order.
My lord,
That prayer is not here.
my lord, that is prayers are to
Sorry,
be.
I am asking you.
If your lordship so kindly gives us leave, we can add this
On the
particular prayers.
Learned advocate, give that order. Learned advocate for the petitioner submits that during the pendency of the writ petition, the subdivisional officer has passed order.
This is
order
affidavit of service.
not required. I am granting you liberty to file affairs challenging this order.
But may I add the particular prayer? Otherwise, again, service.
Petition goes out of the scope of the writ petition. File it and list it. Which order is this? 20th August.
My lord. 20th August.
20th August 2025.
Second July.
2nd July.
2nd July 2000.
2nd July.
Will you copy?
No, not 2nd July. Where is the order of demolition?
Yes, my lord. That is my lord.
June.
Your lordship kindly comes. It starts at page 5. This is the communication. And my lord, page 6 is the proceeding and the orders.
12th June, probably. This is the order. You have the copy of that?
My lord, page number 9 of the supplementary affidavit, my lord, the order starts.
12th June is the order.
12th June.
12th June 2025. He seeks to withdraw the writ petition with the liberty to file affairs for challenging such order passed by the subdivisional officer, Diamond Harbour, 24 Pargana South. In view of such submissions, the writ petition is dismissed as withdrawn with liberty to file affairs. Yes. Yes,
My lord, my writ petition is now my lord, this is your lordship, my lord, so that my learned friend doesn't take steps for few days. In the meantime, we will, my lord, I will visit upon my learned friend, my lord, to lay off their hands for a short period of time.
To challenge this order. So he is withdrawing his writ petition. I am granting him liberty, but he has a submission that in the meantime, no coercive steps be taken so that he can file and move his application.
May I just submit one thing, my lord? My lord, initially, my lord, the writ application was, my lord, initially dismissed. After that, my lord, the division bench assailed the order, my lord, directed the Pradhan, my lord, to conduct an inquiry, inspect, and thereafter, my lord, come to a conclusion. My lord, he filed a review, my lord, against the order of the division bench. My lord, his client, my lord, my learned friend's client. Now, my lord, that was dismissed. My lord, after that, my lord, the order of the SDO, my lord, this has attained finality.
No, the question is that for the writ petition, then my lord, how can
No, I am not on that.
At best, what can be done is you file and then you mention
My lord,
so that we can have it heard.
My lord.
Huh?
My lord, kindly says the grounds, my lord, there's no grounds at all, my lord.
It is something different, my lord. Initially, writ petition filed by my learned friend's client. That was dismissed. My learned friend's client, my lord. It's in my lord, innovative way to evict a particular person who has been in possession, lawful possession. Several attempts for civil case.
A lawful possession with an illegal structure, my lord.
Grateful. Yes.
হ্যাঁ এটা দিয়ে দিন একটু প্রেস ফাইল করবে
কালকে ফাইল করে দিন
38 lawsuit, I am appealing for the petitioner lawsuit.
I'm appearing on the private respondent number 9. Challenging the maintainability of the writ petition as well.
Lawsuit, this is my appearing to service lawsuit.
two APM service. First I served, thereafter I mentioned the matter, and mentioning later also served. Lordship. Lordship, fact
The
is
state is there. Who is the other state?
twice notice was served to the state.
Pradhan is to be seen.
Initially was served the government pleader. Thereafter, Lordship, another notice after mentioning it was served. Lordship.
Really.
Lordship, fact is that Lordship, a petitioner is the owner of the land plot number 487, measuring 5 decimal, and respondent number 9 also the owner of the said land in the eastern side. Petitioner is the owner of the possessing the said land in the western side, but no that is the joint property, no partition by meets and bounds. Thereafter, Lordship, respondent 9 started an illegal construction over the said property without taking any sanction plan, as well as without maintaining the site pace on another thing which was indicated in the law. Thereafter, Lordship, my client filed an application under section 163 2 of BNS before the subdivisional magistrate. Lordship, subdivisional magistrate order, Lordship, page 16. Lordship, first Lordship, subdivisional order, Lordship, page 16. Lordship. 17 is the relevant portion, Lordship. Lordship, second line, if the OP trying to take possession any part of the land as the petitioner that is the prohibited. Further, the OP are restrain any type of construction, revert to or change the mode of the use by use OC Potaspur to look into. Thereafter, Lordship, my client also made a representation before the authority concerned.
What is that?
Lordship, page start from 23, Lordship. 23 is the HDM, Lordship. 25 is the SP. Then thereafter 27 is a Gram Pradhan. Alleging that the said construction is illegal. Lordship, as per section 23, Lordship, kindly direct the authority concerned to consider my representation. Lordship.
My lord, this writ petition suffers from suppression of material fact. It has not been placed before Lordship. Secondly, alternative remedy for which this writ petition is not maintainable. Firstly, my lord, with similar prayer, title suit number 232 of 2025 is pending. Next date of hearing is 11th of August. There is a prayer for, as my learned friend has submitted, there is no partition for meets and bounds. They have preferred this civil suit for partition. Over there, similar prayer is there. Kindly see these two documents. And this is the order. Lord, I have marked for your lordship's convenience.
HON'BLE.
If your lordship takes the Abedon Potro, lordship will find I have flagged for your lordship. Kindly see, my lord. Left hand side is this, the same schedule of property. And kindly see the prayer, which is akin to the prayer A of the writ petition. Similar prayer. They're not to construct any building and to put a stay on it, and they have obtained the order of Order 39, Rule 1 and 2. Already there is an order existing. May I just help your lordship? Kindly, I just place. Kindly,
just fold that.
I'm folding.
I don't know.
My lord will find Bapi Dash, petition number 1 is the applicant number 2 here. Now kindly see page 15 last line and page 16 first paragraph. Page 15 last line and page 16 last paragraph. same prayer, which have been suppressed in the writ petition itself.
Yes.
Now kindly take this order 39 rule 1-2, page 4. I have marked that yellow portion, and next 2 and 3 pages.
Yes.
Kindly just flip through 2-3 pages, my lord. Similar prayer, and kindly see the order also. And kindly see the order.
Still.
Ex parte order has been passed, order 30 rule 1-2. Now there is no whisper in the writ petition that a civil suit parallelly pending with the similar prayer before the learned civil court. Now, my lord, so far sanction plan is concerned, my lord, this is the plan. Kindly see, my lord, we have to consider the fact that it is under a Yojana, Gramin, this housing scheme, this has been done. So this appropriate authority has issued the permission to construct based on my application. And my lord, for these kind of schemes.
Where is the permission?
Lordship?
Where is the permission?
My lord, I have handed over this building plan.
So this is a proposed building plan. Where
proposed building that we placed before the authority. It's not that we have kept the authority in darkness. It's not that we have already approached the authority. It was placed by inspected by the engineers. It is there in the report. Now, my lord, this is an identical issue. This order was passed by the coordinate bench, but it has stated that for the scheme, আমি শেষ করি আগে আমি নিশ্চয়ই দেবো submission করে দেবো. But kindly see, for this kind of scheme, section 23 of the West Bengal Panchayat Act 1973 has no manner of application at all. It says, admittedly, construction under the Pradhan Mantri Awas Yojana does not require permission from the permission granting authority in terms of section 23 of the West Bengal Panchayat Act. This is the observation of the. But I must candidly submit before your lordship, this is under Bengal Awas Yojana, also a housing scheme. But in this kind of housing scheme, there is no specific requirement of permission because these are already inspected by the authorities. Based upon the applications, these permissions are granted.
But then you have to file an application for modification of the order of injunction.
That before the civil court, I would approach my lord. My client would approach before the civil court. But this writ petition is nowhere maintainable.
Okay.
Because
lordship may
judgment.
Copy data.
The facts are different, no doubt, because my lord, that was different. If that particular matter involves that particular scheme, and the
copy দিতে হবে না রিপোর্ট আসলে আমাকে তো কপি দিতে হবে
that is not binding.
So
Second thing, my lord, I think whatever the civil suits are waiting with regard to the my lord title, who is the owner, who is in possession with regard to the title and possession. But so far, section 23 of the Panchayat Act, that is with regard to that under subsection 1, that the plan is to be my lord the object, that is the permission. And the violation of that then comes under section 23(5). That is my lord the power given to the my lord SDO. That to my lord they consider the representation and of tax whatever brought to his notice, and then he has to my lord give an opportunity of hearing to the person concerned against whom the allegation has been made, that the whatever the pakka construction has been made, but without my lord the plan or structure or permission. Then if he my lord fails to satisfy by producing record and other thing, then my lord naturally my lord the steps are to be taken regarding the petition and other. So my lord, the presence of any title suit, whether petition suit, whether other my lord title suit, that cannot stop my lord with regard to the my lord the execution of the my lord the statutory my lord the power, because the SDO power is not limited or might not derogated because of the suit is pending. Only thing whether construction is legal or illegal. You may have right over the plot of land, but the context is that, or whether the issue is that illegal construction or legal construction, then it comes under the section 23 of the Panchayat Act.
What will happen to the status quo order then?
My lord, possibly subject to my learned senior friend's submission.
Let me
It
have
has
some
not been
clarity.
addressed by my
What
learned
will
senior
happen to
friend.
the status quo order?
Yes, no, but only one thing.
I mean,
Since my learned friend has not seen that copy.
Demolish a structure where the civil court has passed an status quo order.
Yes. Similar prayer.
Lordship, to that extent, Lordship, I.
Wait, sir. Wait.
That's why I'm just one thing, my lord. Since my learned friend has submitted, perhaps he has not seen it. Similar prayer, your lordship has seen. Based upon that, the status quo order has been passed. So parallelly, writ petition. Yes, yes. Main prayer. Kindly see prayer A of the writ petition. Kindly for once, and kindly see the prayer of the civil suit. Absolutely identical prayer. They're enjoying status quo order over there in before the learned civil court. Kindly see prayer A in respect of the same plot of land. First prayer is this absolute prayer, which has already been granted by the learned civil court. No, it cannot be. It is not even maintainable.
Lordship, may I permitted to submit one thing, Lordship? Lordship, regarding civil suit, Lordship, I have no knowledge, Lordship, regarding civil suit.
Suppression. Absolute suppression.
Lordship, thereafter, Lordship, the pending of the civil suit only determining the title and other things, Lordship. That's it.
Affidavit of service filed on behalf of the petitioner is taken on record. Learned advocate for the by the present writ petition, the writ petitioner has sought for direction upon the respondent authorities to take appropriate steps for demolition and stopping the construction of the illegal building undertaken constructed by private respond number 9 in plot number 467 Mouja Govindpur Police Station, Ramnagar, District Purbo Medinipur.
Main PDF.
The petitioner contends that the petitioner and the private respondents are the co-sharers in respect of the aforesaid property. The private respond number 9 has undertaken illegal unauthorized construction without taking permission from the concerned local Gram Panchayat. The plot number is 467 or 487?
Plot number 487.
487.
In the prayer, it is wrong. 487.
Lordship, that was typographical mistake, Lordship.
487. Huh? Representation was made before the local Gram Panchayat for taking necessary steps. Sorry,
487.
487. However, no steps has been taken. Hence, this writ petition. Learned advocate for the petitioner submits that the private respondents have undertaken illegal unauthorized construction over the plot in question without sanctioned building plan. He seeks that the matter be relegated to the Pradhan of the local Gram Panchayat to consider dispose of the representation of the petitioner. On the contrary, Mr. S.P. Lahiri, learned advocate for private respondent number 9, at the outset submits that there is suppression of material facts by the writ petitioner. The present writ petitioner, along with along with his mother, filed a suit for partition being titled to number 232 of 2025 before the civil judge, senior division, first court, Kontai, wherein a status quo order has been passed by the court. in respect of the property in question. He finds, sorry, getting the said facts have not been pleaded in the writ petition. Has not been pleaded in the writ petition. The prayer in the civil suit is similar to what has been prayed in the writ petition. He seeks for dismissal of the. Further, he submits that the work of construction, if any, is undertaken under the. Which is this Yojana?
This is Banglar Awas Yojana.
Bangla Awas Yojana, and therefore
For the petitioner. I'm sorry, in this writ petition for the respondent. Banglar Awas Yojana.
as such, no permission is required. Seek for dismissal of the writ petition. Mr. HON'BLE Kumar Sen, learned additional government pleader, appearing on behalf of the state, submits that the he relies on this. It is Manos Odhikari versus State of West Bengal others. Supro. Yes. WPA 18563 of 2020. The same. Submits that the order relied upon on behalf of the private respondent is in respect of Pradhan Mantri Awas Yojana and not under the Bangla Awas Yojana. The scheme and their requirements are different. He further submits that the Gram Panchayat is authorized to examine if any work of construction is undertaken unauthorizedly and illegally as per mandate of law. Tendency of civil suit will not debar the Gram Panchayat from holding such inquiry. ওনারটা না সুপ্রকাশ লাইব্রেরিতে প্লেন্স গুলো ফাইল করেছে ওটা নিয়ে নেবে ঠিক আছে এই যে প্লেন্স গুলো টাইটেল সুটের upon going through the copy of the plain filed at the instance of the petitioner and his mother seeking for partition, it is found that similar prayer for restraining the defendants from making construction has been made before the civil court. Upon hearing the parties, the civil court has passed order. The order to court করবেন এই order দাগ দিয়ে দিলাম entitled suit number 232 of 2025. Such aspect has not been disclosed in the present writ petition. The dispute appears to be civil in nature. In view of the above, the writ petition stands dismissed. View of the above. Dismissed.
Grateful to your lordship. Extremely grateful. May I take back the copies?
No, give a copy of that. We require in the record.
There you go. Let it be. I'm grateful.
Because civil court cannot be passed any demolition order, and illegality cannot consider by that civil court.
Stop. কোনটা Passover?
36 you will also make 2 p.m. 2 p.m.
Here there is another matter.
I had difficulty, but this matter is so urgent for me. I'll come back at 2 p.m. I cannot wait for a day.
এটাকে আমাদের একটা 2 তে আছে না একটা PM 2:30.
Very well.
I'm in the next matter, 39.
Oh, you are not in this. 2:30. Mr. Banerjee 2:30. 2:30 দুটোর সময় আছে ওটার পর 2:30 পরে
Well, in respect of item number 45, 46, 47, I am appealing for the private respondents. So I have a
Come back.
part matter at 2.
Okay, let me come back. Ask your junior to remain. Please.
Grateful, Your Lordship.
টোটাল যাদের ছিল 4 তারিখে বললাম যে আমি সুপ্রিম কোর্টে 4 তারিখে দিলাম 7th আছে 7 না 8 কবে আছে থার্সডে 7 তারিখ 4 তারিখ হুম 25 এটা তো কত আইটেম নম্বর ছিল বলে দেবেন আমি নোটিশ দিয়ে দেবো এইটা প্রবাবলি 35 মানে 35 রেকর্ড আমাকে একটু দিন 35 রেকর্ডটা একটু দিন ও কুশল আছে মানে কুশলকে একটু বলে দিন না না অর্ডার না জাস্ট এমনি ডেট পড়ো
All right, applications will be taken today.
একটু কুশল চালাচ্ছে হ্যাঁ কুশল কি জানি না যেটা 25-এর এই জায়গায় থার্সডেতে আসবে বললো না
Item number 1. Well, time for the state respondent. My junior is on virtual movement.
Lordship, I am on virtual. Lordship, I am led by Miss Nandi.
In this matter, I appear on behalf of the private respondent.
Yes. What is your case?
Lordship, the original complaint of the private respondent was regarding unauthorized construction on the property of the petitioners. My lord, thereafter, being aggrieved by the fact that the panchayat authorities did not respond to their complaints, they preferred a writ application before a coordinate bench of this court. My lord, thereafter, the court was pleased to direct that the panchayat authorities will give a opportunity of hearing to all the parties and dispose of the matter in accordance with law. My lord, thereafter, a resolution.
Which is the order? Which is the order?
The order was passed by Honorable Justice Amrita Sinha in the year 2021.
Writ petition. In which writ petition this order was passed?
It was in WPA 9601 of 2021.
Page 47.
In page 47.
Problem is this, Miller, there is no pagination.
That is also I have paginated, no problem.
That is a problem. 47.
Page 47.
Order dated 25th July
2022.
Okay.
Thereafter, the said procedures were not followed by the panchayat authorities, and a contempt petition was also filed by the private respondents. And in line with that, finally, a resolution was passed by the Gram Panchayat dated 8/8/2024, which is page 51. 8/8/2024, in which the panchayat authorities they stated that the construction was unauthorized in nature. My lordship, my contention is that the original complaint was regarding a pakka construction. A pakka construction was under suspicion of being unauthorized. But I'll come to it later. Aggrieved by this order, Your Lordship, we preferred a writ application before another coordinate bench of this court, that is Justice Ravi Kishan Kapoor, who ordered on 14/1/2025, that was in WPA 22873 of 2024. It was ordered that in line with the previous writ application and the order thereafter, the SDO this time, my lord, was directed to conduct a hearing under section 23(5) and pass a reasoned order by giving opportunity of hearing to all the parties. My lord, thereafter, I was sent a notice dated 16/6/2025, which is the impugned order, my lord, by which the SDO has communicated his order by stating that the Pakka constructions which have been alleged to be unauthorized earlier were found to be in line with the PMAY Gramin Yojana. But, your lordship, additionally, it was also found, according to the SDO, that there were certain constructions which were kacha in nature, which were supposedly unauthorized, which are A2 and A4 belonging to Bindaban Haldar and Subal Haldar. While the Pakka constructions were cleared to be in line with the PMAY Gramin Yojana, it was said that the kacha constructions were unauthorized in nature. Lordship, my contention is that the kacha structures in question, they have been in existence since 1966. I have annexed the deed, my lord, and also the tax bills regarding to the property. The tax bills, your lordship, clearly shows, even as far back as 42 years ago, that there were kacha constructions on the site. Your lordship, the total property is around 7,500 square feet, the total appurtenant land, if we convert from the decimals. Lordship, no new structure was constructed thereafter. Kacha structures, the only structures that I have constructed after were the Pakka constructions which were found to be legal. The kacha constructions were always there since even before 1966, because the 1966 deed by which the property was purchased, even there it is, your lordship, in vernacular mentioned Bosot Bati. So the kacha construction.
You have not annexed all the orders.
I have
Yes.
with the compliance. Well, I will hand over my learned friends.
There are other writ petitions also. There are contempt petitions. Those orders have not been annexed to the writ
The
petition.
contempt petition, your lordship, we were not even made a party.
One
So we were
reference
not
of
even
the
aware
writ
of a contempt
being
petition.
18163 of 2022.
Well, I will make.
Yes, your lordship, because
18163 of 2022.
we were not made parties. The only ones I have annexed are the ones where we have been made parties. We were not party to the contempt petition, your lordship. We were always kept in the dark regarding the contempt petition.
Okay. So you say that your structures are old ones.
The kacha structures.
And the
Pakka structures are new constructions that we admit. But that was only
Correct.
because of the funds that we got from the poverty alleviation scheme, that is the PMAY Gramin. And the kacha structures, which were later on found to be unauthorized on the basis of a separate field survey, field report, that were, my lord, already in existence since before 1966.
But I have submitted my BLO's report yesterday, as well as
My lord, may I
the
stop it?
report of the SDO.
Didi, I bole dichi. My lords, kindly come to my lords. There is the allegation of unauthorized Pakka construction. I came before this honorable court, and my Lord Justice Amrita Sinha directed the statutory authority to, after proper inquiry, if it is found in violation of section 23(1) of the West Bengal Panchayat Act, appropriate order shall be passed. So now kindly come to the document which has been annexed to the writ petition. Schedule of the property. So for my designation is page 21. তোমার কতটা দেখাও তো? Schedule of property. Well, this is the schedule of the property. Didi eta. Or aqua. Malad got it?
21.
21.
So now the plot is very vital. 1286. Total area, my lord, 15 decimal. The first petitioner is concerned. He is the owner of my lord, 1.5 decimal lands. That means, my lords, is
1 and 1/4.
1/4. That is the 11. So now he is not the absolute owner of the plot in question. That is the undivided land.
Okay.
Well, I am coming, but Lordship, I am giving the point of this is the document which has not been annexed, but that is the order. I
Milord, my junior is here. Milord, Lordship, kindly allow me, Milord, to come from courtroom number 35.
So, entire facts I have been narrated short notes. Now, second, this have got it. This is the point later on. We will go to my short notes of argument. So now he is not the absolute owner of the plot in questions. Now, a civil suit has been filed by the private respondent regarding partition of the land in question. But I am the co-owner. An injunction order has been passed in 2016, not to change the nature and character of the land. So now, in violation of the said injunction order, so that is the partition suit will declare our the share. But in violation of the civil code order, as well as violation of section 23, one of the West Bengal Gram Panchayat Act, they have started the construction. I lodge a complaint. Because of the statutory the provision violated, the writ court has the jurisdiction. It is the settled proposition of the law. So now the civil code will not decide the statutory violation of any statutory provision. That is the settled law. I will cite the judgment which has been handed over to LRC. Now I came before this honorable court after lodging the complaint. Now what order has been passed, my Lord Justice, kindly see, my Lord Justice Amrita Sinha. So my Lord, this is the order dated 25th of July 2022. My paging 47. My paging
47.
Now kindly see, third paragraph. The petitioner complaint of illegal and unauthorized construction at the instance of the private respondent in the undivided land in plot number such and such. Got it? So now there was a direction to inquire the records whether there are any unauthorized construction without sanction plan or not. Now the fact-finding authority being the Gram Panchayat, on the threat of the contempt, they personally appear before this court, violation of this order, they have not complied with. An order has been passed by taking into resolution page 53. So far my presentation is 53. So now the 53, my lords, if your lordships, the fact findings after thorough inquiry in presence of the petitioner before your lordships. Whereas, my lord, this is 54, so far my presentation.
54.
My lord, the 54 second paragraph. Whereas inspection of the concerned property of Sri Brindaban Hallar, herein petitioner before your lordship, Loli Hallar and Subol Hallar at Dulalpur Mandir Bazar was conducted by Gopal Sarkar, Nirman Sayak, Krishnagam Panchayat in presence of the Pradhan Krishnagam, and based on the report, Gopal Chandra Nirman Sayak, Krishnapur Gram Panchayat dated Sajana, it was found that a building had been constructed on the property Sri Brindaban Hallar, petitioner before your lordship, Sri Lolid Hallar, petitioner not. Second petitioner Subol Hallar are measuring in. Mala, this is a very vital 9.
Lordship, may I? For 1 second. Lordship, the structure which is being questioned here is the Pakka structure, which is of 595 square feet.
Then I will come. What is that? Now, the ultimately the statutory authority, that is the fact-finding authority, pass an order under section 23, subsection 6 of the West Bengal Gram Panchayat Act. So that is the fact-findings authority decision. Now kindly come to my lord, this is the section 23, subsection 1 of the West Bengal Gram Panchayat Act. Now my learned friend raised that I have the constructed with the brick without roof. So now provision my
no, I have not said constructed
I am
brick.
coming,
I have said mud.
order. Kindly come to page 23. Control of the building. Section 23, subsection 1. Got it? No person shall erect any structure or new building or make any addition, any structure or building having plinth area of not more than 150 square meter and height not more than 6.5 5 meters in area within the jurisdiction of the Gram Panchayat except with the previous permission in writing in the Gram Panchayat, provided that where the state government and authority, the agency under the government intend to set up an industrial estate. So now the construction, the court, fact-finding authority held the unauthorized construction without sanction plan. Matter referred to the SDO. They came before this honorable court without challenging the fact findings order which has been passed under section 23 subsection 6. They approached before this honorable court.
No.
So now the decision which has been passed by the statutory authority under section 23 subsection 6, they have not challenged in earlier proceeding. Today also they have not challenged. Matter referred to the jurisdictional subdivisional officer for passing and further appropriate order under section 23 subsection 5. Now come to the, my lord, this the fact findings. Again, my lord, this the order of the statutory authority. My lord, this the
been challenged here.
Lordship.
What has been challenged in the writ petition?
Order has been passed by the fact finding authority on 20.
The order of the SDO is being
That is
challenged.
the, my lord,
It's under.
I am placing, my lords. So now they have challenged the order dated 12th of June 2025.
No. 16th June.
Yes, Your Lordship. 16 June 2025 of the SDO, Diamond Harbour.
12 June.
Order the communication. Order.
So now, my lord, is kindly see, this is the order. My lord, this is annexal last 12th of June 2016 to is the communication.
Yes.
I don't know, my lord, I have no communication
1606
annexed
is
with
the
my writ petition. However,
1606. That is the order sheet. Huh? 16 is the order.
12th June.
Communicate kora.
my lord, that is the, my lord, kindly see, my lord, my learned friend Riley pointed out, kindly see the communication which has been made pursuant to the order passed under section 23 subsection 5, that is communication 16th of June 2025. So now there is the enclosed we find here with the order dated 21st of November 2024 and 12th June 2025. Well, the communication got it. Now the communication which has been made, that is the final decision which has been passed under section 23 subsection 5 of the West Bengal Panchayat Act. So kindly see the page number 68. 68. Mala the 68.
60.
Yes. Now the 16 is an order has been passed. Prior to that, my lord, if your lordship kindly see the findings of the statutory authority, that is the SDO, 19th of May 2025. Is the top, my lords, in the 68 page top. Got my lordship. Now, one, my lord, Lolit, I am not A1. A2, petitioner has come before your lordship. Subol Hallar. My lord, got it?
A2. Yes,
A2.
Subol Hallar, yes.
Subol Hallar, petitioner number T2. My lord, this is the area or my lord, the carpet area. Kindly consider this is very vital. Carpet area. So petition number 2. 495 square feet. What it mean? Then big build structure covered with asbestos of Bindaman Hallar. That is the petitioner number 1. Malada kindly got its area.
432.
A3. A big build another 100, 200, 35 square feet.
Yes.
Then, my lord, this is the kindly come to A4. 432 square feet. Now, according to document deed which has been annexed, the Bindaman Hallar is the owner of 1.5 decimal.
Lordship, we are admitting that it is a joint property which belonged originally to the father of the petitioner.
That is the now they have come to the conclusion that The construction has been made under the scheme of the below poverty category scheme. The permission is not required under the same scheme, Rule 19 sub 1 of the West Bengal Gram Panchayat Administrative Rule.
Yes.
Admittedly, he got the money. There is no dispute. That sanction of the money on the undivided land, that is also in violation of the law laid down by this Honorable High Court. Because of that, you can construct 1,20,000 limit area only 25 square meter. That means, my lord, 270 square feet. Apparently, on the face of the record, my lord, he have constructed 1,235 square feet. So I have handed over the scheme of my lord, the PMOI, the square, my lord, this, if your lordship kindly go to that. My lord, this the, if your lordship, page number 3, the record of right shows in the name of Bindaban Haldar, petitioner number 1. My lord, got it. So now, right side, my lord, Montobbo, 5 khana ghor. My lord, then I will come. Got it? Then, my lords, and my lord, the injunction order has been passed by the civil court not to change the nature of character of the lands. If that is the, my lord, the civil court will decide our portion of the share of the civil court, that is not bar in the writ court to, my lord, adjudicate for violation of any statutory provision. So I will, my lord, I have already annexed the document, judgment of this honorable court. Now, lordship kindly come to PMOI scheme. Pradhan Mantri Awas Yojana.
Lordship, I'll just take 1 second before my learned senior friend continues. The question he is raising.
This is the page 7. Page 7, my comprehension. My lord, kindly see. Page 7, got it, my lord? So now bottom portion, key feature of the PMOI G, gramming. Got my lord? So now a minimum unit house size 25 square meter.
Okay, either no. Hey, এই জিনিসটা দিন একটু। দাও ওটাই দাও না। Yes.
The 25 square meter means, my lord, I have calculated that 270 square feet. About 270 square feet.
270 square feet.
Lordship. Now he has come each. Both the petitioner has come before your lordship, that has been recorded by the SDO while before passing this order, recording in presence of the petitioner that he got the funds from the government for making the construction. He should construct about, my lord, 270 square feet. That is also illegal. Because of that undivided land, the authority concerned
That
has
point
not
was
given
never raised.
power to construct an undivided land and or sanction any fund on an undivided land. Even then, the civil court is no, my lord, the authority to adjudicate unless and until he will declare absolute owner of the lands. So why I will approach before the civil court? So now the authority, statutory authority, decide the partition and meets and bounds. So that is the 270 square feet, my lord. He has the right to construct from the funds of the government PMI scheme. But he apparently, on the face of the record, he has constructed Paka building 1,200. So that has been 68. My lord, kindly got again, my lord, I am coming. So Bindaban has been constructed 1,230 square feet. So then, my lord, rest of the portion 1,235 minus 270. Rest of the portion, the construction has been, which has been made, that is illegal without sanction plan. That is my first respective submission. Second submission before your lordships. My lord, this is the 2. Bindaban as well as the, my lord, the Subol. They got the money under the scheme of PMOI. Taking advantage of the money, they will construct more than the statutory the provision which has been laid down in the PMOI scheme. So that is the first point. Second point, submission before your lordship. How the fund has been sanctioned in an undivided land without taking consent of the owners. I got this point. Third point before your lordship. A fact-finding decision which has been, my lord, passed by the statutory authority under section 23, subsection 6 of the West Bengal Panchayat Act. Has not been challenged in the writ petition. A fact-finding decision cannot be challenged in a writ proceeding.
Absolutely.
I will show the judgment of the my lord honorable Supreme Court.
But if there is no appellate authority,
Lordship?
if there is no appellate authority,
There is no appellate authority.
Appellate authority, Vishwajit Pramanik, that authority is the SDO. They
It is the order of the SDO.
By way of an order of my Lord Justice.
So, Lordship, we have come challenging the order of the SDO.
will you continue like this, then I cannot understand anything. What do you want to say? You complete, then I will allow him to speak.
Let him come.
Yes.
So now they have not, the Vishwajit Pramanik case, Lordship has considered that judgment has been upheld by the division regarding the appellate authority acting. SDO will act as an appellate authority after passing an order under section 23 subsection 6 by the Gram Panchayat. Then the appellate authority is the SDO to pass an order under section 23 subsection 5.
But
they came before this honorable court.
But they have challenged the order of the SDO.
SDO. Then the order, they should challenge before your lordships order which has been passed by the fact-finding authority, by a statutory authority, that is the Gram Panchayat, along with the judgment order which has been passed by the SDO. But here in pair is only challenging that the order of the SDO. Apart from this, that fact finding, that is apart from this. Now the 3 point I have laid down, submitted before your lordship, the construction apparently on the face of the record beyond the scope of the PMOI scheme. Second submission before your lordship, the 270 square feet, my lord, I have no objection. But above 270, my lord, the 70 square feet, permission is required. Where is the permission? If he has the permission, I have no case.
Then what about Subal?
Lordship?
Subal?
Subal, they are the same. He got the sanction fund from the government. That is also, my lord, above the 270 square feet. It appears from the record. Kindly see. Malada, so far the Subal is concerned, the findings which has been recorded by the SDO. So, my lord, I cannot raise this objection. The Subal part is this, because of that, his permission is also not required, but he has misused the money, public money. He got the money, but no construction. But it appears from the Kacha structure with Subal Haldar. So that I will take the appropriate step before the approach. So far the second writ petition is concerned. But on the face of the record, my lord, so far the petitioner number 1 is concerned, when a construction has been made above 270, rest of the portion, his sanction plan is required. So there is no illegality, infirmity in the order passed by the, my lord, the subdivisional officer as well as the statutory authority, that is the Gram Panchayat. pursuant to the order passed by a coordinate bench.
But this order has not been passed for demolition of the extra square feet which you say. This has not been passed in this.
Lordship, then your lordship, my lord, this the so far the unauthorized construction is concerned, on the face of the record, lordship has the power to exercise the jurisdiction under Article 226 of the Constitution. I can, my lord, take steps in accordance with law regarding the extra part is concerned. So now apparently a multiple proceeding cannot be initiated against sitting in the, my lord, the same order. This court has been held, my lord, kindly see. Well, I have pointed out 3 points. One is the undivided land. Without consent of the co-owners, you cannot make any construction, no fund can be sanctioned.
Where is that point in this?
My lord, this is a decision which has been passed by this honorable court. My lord, is a first of all, my lord, is a kindly come to page number. My lord, Justice Rajasekhar Manta. In my case, I lost this case, my lords. Penalty page 27. 26 is the very, I have heard the found from the submission made on records produced before this court that the both party petitioner and the 7 respondents are the joint co-owners and undemarcated property. My lord, got it? My lord, this is page 26. Paragraph 1, 2, 3, 4, 5. 5. I have.
কত বললেন টেক্সটটা কোনটা বলছেন
না আমি একটা জাজমেন্ট রাইট করছি মানে পেজ 25 judgment passed by the honor.
No, page 24 is the judgment.
So my lord, this 9th of January 2019. Lord, grateful to Lord. My lord, this internal page is 2.
2, yes.
Yes. I have, however.
Yes.
So now, found from the submission and the record produced before this court that both the first petitioner and the 7th and 8th respondent are the joint co-owners and undemarcated property. A portion of the property in alleged occupation of the 7th and 8th respondent has been obtained under lease and reliance comparison. This is also undisputed fact. The lease in the question is ex officio defective, since the property has not been demarcated by and between the first petitioner and the 7th and 8th respondent. So now here in the partition suit is pending undemarcated land. So my lord, according to his own will, my lord, he will make the construction and anywhere. Since I permission is not required because of that I got the funds. So now undivided land without taking my consent, the ultimate paragraph, my lord, since this is an undisputed question of fact, article sergeant son, my lord, then 226 court, article 2, next page, my lord. Enter into this issue to why without verification of the list and absence of consent of a joint co-owners of the property, the mobile service provider has claimed a right over a property to construct and erect and has already a mobile tower services, and how the Gram Panchayat concerning issue the permission thereof. So now question before your submission before your lordship that how the fund has been sanctioned for construction on the undivided land. First submission. Herein then my ultimate prayer is this: sanction has been granted the Panchayat, that sanction has been declared null and void. Another division bench also, my lord, is my lord sitting in my lord Justice Devanshu Bosar, recently held in 2025, paragraph 14. Page 20, my lords. There is no material on record to establish that there was a partition amongst the owners of the 2 plots of land by meets and bounds. The reliance is placed on a site plan claimed to be signed by the private parties on behalf of the appellant to contend that there was a partition amongst the private respondent by meets and bounds. There was also a civil suit declaration of partition filed by between the ultimate held without consent of the parties. Even my lord, we have jointly meets and bounded the property in question. That is also not valid by held by the division bench. So now there is the 3 point is this.
In this scheme, is there any clause that consent has to be taken in case of a joint property?
No, Your Lordship.
That is the issue. That issue, apart from this, a sanction of the fund, rule 19(1) does not permit by taking advantage of the fund. If he is absolute owner, then permission is not required. If it is the co-owners, other owner is there taking advantage of the fund. Suppose I am the owner of the particular portion, occupying the portion. Now taking advantage of the money, my lord, he will construct inside of the road. So where this is undivided, undemarcated, that issue has not been decided. Everybody will do this thing. My lord, managing the Gram Panchayat or any other authority obtain certain money. That I got the money for making a construction. No partition is required. No sanction plan is required. Everybody will misuse these provisions. The provision is very clear, my lord. Kindly once again see rule 19(1). So then tomorrow also I will, somebody else will get the money, a joint property, according to his own will, will make the construction where I was in possession. That is the misuse. Kindly rule 19(1). If he is absolute owner of the plot in question, permission is not required. But that does not mean by taking advantage of the fund, he will make the construction beyond the scope of PMIS.
But where is the provision which tells us that consent of all the parties is required, even if it is a joint property? Is there any specific provision?
270 limit is there.
Is there any
He has
specific
constructed more than the scope of the PMI scheme. So that is also apparently on the face of the record. When records before your lordship can pass appropriate order, either modifying this order or not to interfere or as your lordship. Then I have the liberty either to challenge by a separate proceeding that permission,
Exactly
rest
my
of the
point.
person held, then I have no case. 270, then your lordship has to be dealt with regarding undivided land, unpartitioned land. He has the right to construct or not. That is also required to be dealt with by your lordship. Then everybody, every person who got the money or will got the money, everybody will get the benefits. 270 undivided land.
But then if the order is not challenged by you, how can this court modify that order?
Your Lordship, they did not even challenge this order
His
before
portion,
the concerned authority.
unauthorized portion that cannot be, my lord, interfered by this court, but rest of the portion, lordship can exercise the power. Court cannot shut the eyes. My lord, this is the latest judgment of the Bonusri Mondal, my lords. It is the duty bound on the part of the statutory authority without any application. If it is found there are unauthorized construction, so motor proceeding has to be initiated.
No.
That is the judgment of the, my lord, the Honorable Supreme Court.
Why the SDO has not held so?
So that is the, my lord, this is the, I have the liberty. I have the liberty to, my lord, the challenge. First of all, what is the wrong? Wrong part is my part. I have not taken that step. Rest portion has not been. Lordship can exercise the power under Article 226. Because of that, Supreme Court say, if it is failed to, my lord, the comply or the statutory duty, Supreme Court held the statutory authority has to be dealt with in accordance with law. Because of that, he has not discharged his statutory duty. So I will tell, either your lordship can exercise the power under Article 226.
Something has to be on record.
So now I have given the lordship on the face of the record. Face of the record, 215, my lord, the Article 215, the record on before this court, my lord's court can exercise the power.
No, bring on record the facts. You have to state by way of an affidavit that this
So, my lord, the affidavit, it will be, my lord,
in
this
violation of PMI. You are not challenging the order. You are
No.
not agreed by the order.
I am rest, my lord, so far the rest portion is the concern. I have not challenged. Lordship can exercise in this writ petition when the record is available before your lordships. First submission. Second submission.
You have not challenged the order.
No.
You have challenged
What
the
is the wrong of this?
Wait, let me put the question, then you give your answer.
Lordship.
A2 and A4 has been held to be an illegal construction. This order has been challenged by them. They say this is an old structure.
Old structure.
Now you are agreed by A3.
Maladis, I agreed A3.
A3 is in excess of what has been granted by under the PMAY. There is no writ petition.
No writ.
There is no pleadings to that effect.
Yes.
So until and unless that comes up before the court, how the court will decide and interpret?
Now the what held by this authority concerned held that the money which has been sanctioned, kindly last relevant portion. Now I am in the capacity of SDO, page 71. Subdivisional officer. In exercise of the power conferred upon the subsection 5 of the Section 23 of the West Bengal Gram Panchayat Administrative Amendment Act 2017.
No, Mr. Haldar.
My lord,
You file at least an affidavit to this effect that you also agreed by this order there is a violation of PMI scheme.
Only one part.
And unless that is there before the court, how the court will decide this aspect?
So far the
and the order of A2 and A4, you are not agreed by that, they are agreed by it.
No, they are entire order which has been passed.
No, not entire.
Kindly see that entire order. Building
an order is passed in respect to A2 and A4. They say
so where is said so? Nothing has been said so.
Come to the other page
Clear in the
66.
order,
It is.
page 63.
63.
I am satisfied that Kacha house with mud roof.
66.
Paragraph says 432. Vrindavan. 432 is A4. And 495.
Malad A2 is I am no objection. So far the construction is no. He has challenged the entire order.
No.
Order of 12th of June.
No.
Even if the entire order is challenged, there is no such order for demolition.
We have not
of
made any pleading
remove
with
the
regard to
unauthorized
A1 and
portion.
A2.
Remove the which unauthorized construction.
So that is Malad kindly see.
Go through the orders. I am satisfied that these Kacha are illegal construction.
Malad is then my lord I can only give the one suggestion before taking note of my submission. Refer the matter for remand and stay or after setting aside of this order, remand the matter before the SDO. I consent. I am giving the consent before your lords. Malad this without calling any because unnecessary malad this stall the matter before your lordships or after malad that 3-4 years matter will decide. Ultimate malad remand the matter. I agree. So my lord take a note in submission, taking note in consideration my submission. Remand the matter.
Lordship. Lordship, may I submit one thing, Lordship?
Yes.
Lordship, if your Lordship kindly come on my report, Lordship, which I filed on yesterday, report by Lordship SDO.
Yes.
Yes. Now, Lordship, if your Lordship kindly comes on paragraph 7, Lordship.
Yes.
Paragraph 7 is that, Lordship, on 19/5/2025, report received from BLR Nelaro, Mandir Bazar, Bhait memo number such and such, dated such and such, where it has been reported that on the suit land, one Lalit Haldar has a kacha dwelling house of 675 square feet, two that is marked A1, and then two Shubal Haldar has a kacha dwelling house of 495 square feet that is marked A2. Then Brindavan Haldar has a brick wall dwelling house of 1235 square feet that marked as A3 and has a kacha dwelling house of 432 square feet marked as A4. Now, Lordship, kindly comes on next paragraph, Lordship. That is paragraph 8, Lordship. That is on 12/6/2025, report received from the Pradhan by his memo number such and such, dated 3/6/2025, where it has been reported that house marked as A1 and A3 are constructed under, that is Pradhan Mantri Awas Yojana scheme, hence exempted from taking permission. And then, Lordship, house marked as A2 and A4, which are not, Lordship, under this scheme. Lordship, now Lordship kindly comes on next paragraph, that is paragraph 9, Lordship. That is after considering all the reports and documentary evidence, it is received that the area of the both unauthorized Kacha house marked as A2 and A4 are above 18 square meter, which overruled the under section 23(2) of the West Bengal Panchayat Amendment Act 2017, Lordship. That is my report, Lordship.
How this report will come conclusion
So
after
try to understand. A2 and A4 is a Kacha structure. There is a
Yes.
order of demolition which is aggrieved, that petitioner is aggrieved.
Yes, Lordship.
Respondent raises the issue that how he has constructed 1200 something square feet when the PMOI scheme says it is 270 square feet.
Lordship.
Not that for taking permission under the PMI you will make a large voluminous construction.
Lordship, under this scheme,
As a
Lordship,
restriction which has not been decided by the SDO.
Lordship, under this PMAY scheme, Lordship, there were no permission can be taken, Lordship, necessary as per my instruction, Lordship.
Permission is not necessary to the extent which is limited in the PMOI.
Yes.
You cannot make a two-story building under the PMOI.
No.
Correct. So there is a limitation of what Mr. Haldar says, 270. The SDO has not decided about this aspect of A3, being it is more than 270 square feet. Huh?
Lordship.
I think the matter should be remanded.
Okay, Lordship, the relief that he is claiming for, that is that exactly that should be set aside, but it is an entirely different cause of action. That is the problem. He cannot claim relief in my writ petition, right? Exactly. Then the entire order let it be set aside and remanded to the lower SDO.
This writ petition is filed seeking for setting aside of order dated 12 June.
12 June, yes.
12 June 2025. Passed by the Sub-Divisional Officer, Diamond Harbour, South 24 Parganas, for demolition of structures indicated as A2 and A4 in the said order. There is no such indication of your construction with regard to 1275.
No.
Learned advocate for the petitioner submits that the structures denoted as A2 and A4 are old structures. The new structures have been constructed under the PMAY scheme, which does not require permission. He seeks for setting aside of the said order. On the contrary, Mr. Stated case, State, who is for this?
Lordship, I am for state, Lordship. Mr. Soumyajit Ghosh, led by Mr. Sanghamitra Nandi.
On the contrary, Mr. Pankaj Haldar, learned advocate for respondent, private respondent number 9, submits that under the PMAY scheme, a minimum unit bracket house size is of 25 square meter. You have checked 25 square meter?
Lord, I have, my lord, the document scheme has been annexed.
25 square meter is 270 square feet.
Lord, I have checked. I have
Lordship, 18 square meters is
269.3.
231. 18 square meter is 231. But 25, I don't think it can be 270.
My lord, 269.3.
18 square meters is 231.
So you have a mobile, just
I'll check and I'll.
check and tell.
270.
270 square
Okay.
feet. Now, as per the impugned order, the construction of the house denoted as A3 is 1235 square feet, which is
269.
in excess of the limit under the PMAY scheme. Therefore, the extra construction has been made without necessary permission. That apart, the consent of the co-sharers have not been taken prior to making application under the PMAY scheme. Learned advocate for the state submits that no such permission is necessary in respect of a construction undertaken under the PMAY scheme. In the impugned order, the subdivisional officer responded to the has had observed that. Can you just indicate, Mr. Haldar, where the SDO has observed that there is no necessity of any permission? Has observed that in terms of sub-rule 1 of rule 19 of the West Bengal Gram Panchayat rules 2004, no permission of the Gram Panchayat shall be required for construction of houses under the poverty elevation program. Be that as it may, the Pradhan Mantri Awas Yojana PMAY provides a minimum unit house size of 25 square meter, including a dedicated area of hygiene cooking. The order impugned shows that the structure denoted as A3 has an area of 1235 square feet, which is more than the minimum unit provided under the scheme. In view of the above, the impugned order passed by respondent number such and such subdivisional officer appears to be infirm. Accordingly, the same is set aside. the subdivisional officer, the writ petition is disposed of, directing the subdivision officer Diamond Harbour to consider the matter afresh, taking the PMAY scheme into consideration while deciding the aspect of legality of construction with regard to A3. With regard to the structures constructed in the plot in question, subject plot, under the PMAY scheme.
And the undivided portion.
That cannot be gone into by
Other aspects will be left open. You agitate before the SDO?
Well,
No.
Kindly record. All parties are left open.
So
to
these are
All the points are left open to be decided by the SDO. No. Is writ petition disposed of? Within a period of 6 weeks from date of communication of this order. Parties are at liberty to produce all relevant records before the
Grateful, Lords. Grateful.
application আছে, interim এর extension আছে, কটা বাজে? 3টে বাজে। কোনো আড়াইটের সময় একটা ফিক্স করেছিল, ওটা ঘুরছে তো। আড়াইটের সময় কোনটা বলেছিলাম? ওখানে যাও তো। All the site.
Grateful, my lord. I have already completed their millet and come.
Okay, it has been sent to the SDO to decide afresh.
My lord.
Since there is a violation of the limit.
My lord.
I pointed out.
Grateful, lord.
Okay, thank you.
But I was appearing on behalf of the petitioner.
Petition. বাঁধা ঠিক আছে থাক all the parties are there.
Yes, my lord. Everyone is here.
Here for the state.
I'm for the panchayat. No, I don't know who is appearing for the state.
My lord, my grievance is against panchayat. So, my lord, presence of
No,
panchayat will do.
We are concerned with the resolutions of two days.
Oh.
Where is the state? He was there in the afternoon.
State.
He was state.
My lord, Mr. Dhar is state personified. My lord, so.
He's for panchayat. Now he's not. Mr. Mondal, who was for the state in the early hours?
Then today is no adverse order, my lord. Not to pass any adverse order without the.
কালকে দেখো তো দুটোর সময়। Do you know who has been assigned?
No, my lord, that my lord, I may inquire. My lord, I can inquire.
Give a notice.
Today being a special day, my lord, I cannot also insist upon my lord the matter being taken up.
কালকে দুটোর সময় দেখা কালকে।
No.
Oh, my lord, I'll just check. Oh,
It is not a party.
my lord, I'll just check.
Give this state as a
My lord, my learned senior friend is correct.
Take it.
My lord, panchayat authorities are parties, then subdivisional officer, my lord, is a party. If my lord, Mr. Dhar is representing SDO also. 1, 2, and 3, I'm sure, my lord, Mr. Dhar is representing.
Yes.
But 4 and 5, my lord, may I open my case? I know, my lord, I'd be prevented. 4 and 5 are, my lord, possibly state authorities. 4 is, my lord, subdivisional officer. I do not know, my lord, whether my learned friend, my lord, is briefed by him. And, my lord, 5 is, my lord, the police authorities.
Private respondents.
Private respondents are represented. They are here, my lord. They are here. 4 and 5, my lord, they are not here. But, my lord, there is really no relief, my lord, claimed against 4 and 5. May the sole subject matter of challenge is, my lord, something which has been done by Mr. Dhor's client.
Oh,
I have done the mischief.
My lord, to be precise.
give a notice to the state.
Very well, my lord, I will have notice on that.
Tomorrow, দেখো তো কালকে 2টোর সময় তাহলে নেবে।
My lord, tomorrow, my lord, second half I am not there. My lord, kindly, my lord, take it up in the first half. Then second half, my lord, I am not there.
So expunge the name of SDO.
That, my lord, I cannot do. That I cannot do.
That is what I'm saying. This SDO can
But
be
they are
expunged,
together.
then we can
Panchayat and my lord,
the
Mr.
party
Chakraborty's
here.
client are together. That, my lord, I
No,
cannot
I
do.
will not do that.
And my lord, everyone knows Mr. Chakraborty's client and Panchayat are together. That's, my lord, my grievance.
See, the presence of the state is to be. Did anybody appear in the first half?
No, 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 no.
Tomorrow you're not there.
Second half, my lord, I'm not there.
I can take it up depending on how many POXO matters will be there tomorrow. At 12:30, we can also start 12:30.
Mr. Chakraborty has orchestrated this today. The matter was taken up.
The joint prayers of the parties. দেখো তো 7 তারিখে আমি একেবারে 2 PM.
7th আমাদের
Seventh.
বাইরের কোর্ট আছে না? The 7th minute I have a Supreme Court.
8 তারিখ 8th.
Minute 8th is fine.
Find out Mr. Chakraborty. You're not there.
First half.
Again, the first of the same problem remains tomorrow as of 8th.
কি আছে? মানে kindly grant me a moment.
On 7th, it is fine.
Seventh, I'm not there.
চলো 8 তারিখে থাক।
We'll try our luck. We'll not on 8th then.
Tomorrow or 8th?
8th. We'll try our luck. কাল নেই আমি সেকেন্ড হাফে, ফার্স্ট হাফে যশ সাহেবের হবে না তো, সেকেন্ড হাফে আমি নেই রে। আর একটু ভাঙুক তারপর করে কি করব, তাহলে 14th কর, আর উপায় নেই তো কিছু।
14th দিও। Both check your dates. Where you are? 14th. Mr. Manaji, 14th.
14th.
Find out who is for the state.
Yes, Willard, I'll
On the
inquire.
joint prayer of the parties, list this matter
I'll
14th
inquire.
August at 2 PM.
So grateful to you, Lord. Great.
Deeply.
Okay, application. Twenty, not today. Not today.
21. No, for the petitioner.
Madam, for the state.
What is the application?
Yes, my lord. Affidavit of service, my lord.
Application is?
Is my lord restoration and condonation of delay.
When was this dismissed for default? 24.
Dismissed or default on 1st July 2024.
How many days then?
21 days, my lord.
What is the period of limitation?
30 days. 30 days, my lord.
Why did you file an application for condonation of delay? If there is no delay,
Lord, 20 days of delay, my lord. I have filed the application on 20th August and dismissed on 1st July.
But after completion of 30 days, 21 days delays is there.
oh, 1st July, 30th July. Okay. ঠিক আছে. What is your submission? The other side. All have been served.
Yes, my lord.
Panchayat is the answerable authority.
Panchayat wasn't served, my lord. I have filed another.
Pradhan, served. And
Pradhan,
any
sir.
private respondent is there. They have been served.
Yes, my lord. All respondents are served except there was an
Respondent. Hey, Baba. Oh, তো কালকে রাখো এটা কালকে এটা দিয়ে দাও tomorrow. Private respondent, anybody is there for private respondent?
no, my lord.
Tomorrow. কালকে রাখো application.
No.
22, I am for the petitioner, my lord. Contempt application. What has not yet been served, my lord. Your lordship's order at page 17, my lord. Sorry. Your lordship passed the direction upon the collector, that is respondent number 2, my lord, on the basis of my representation to decide the matter. This is with regard to my lord. Yes.
Who appeared?
I have not yet served, my lord, since it is contempt application. Unless your lordship's direction is there, I cannot serve.
This contempt petition
Yes.
arises out of order dated 30th January 2024. Petitioner is directed to serve notice upon the who is the person? Who is the alleged contemner?
My lord, alleged contemner is collector.
Alleged contemner. Collector Purbo Mendipur?
Collector, yes. Purbo Midnapur and the district magistrate having office. The same designation.
Please this matter on and आगे कोई बोले जो file affidavit of service on the returnable date this matter after 15 days for a date.
Applies to your lordship.
Next.
Twenty-three, my lord, I am appearing on behalf of the petitioner, my lord, led by Mr. Royan Banerjee. It is a contempt matter. Last occasion, your lordship directed us to serve upon the contempt note, my lord. We have served, my lord, but affidavit of service is ready. But today, due to the, if your lordship kindly fix it, yes, sir.
Tomorrow.
Yes, my lord. I am grateful.
Extension to রাখো RTS 23 তো হলো হুম
24, I am for the petitioner. My junior is there in physical mode.
You are
But,
there?
kindly have a look to your lordship's order dated 30th of June 2025. The second page, scan 2 of 2025, extension of interim order application that was filed by my client. Your lordship was pleased to extend the interim order till end of this July.
End of July, yes.
Yes. So today is the day when it's appearing. It's expiring today. The matter is otherwise ready for hearing if your lordship skips any day for hearing.
Who is for the added respondent? Who is the added respondent?
Mr. Shobboshaji Chatterjee, no, his junior is there.
So this matter is appearing under the heading extension of interim order. Mr. Sarwar Jahan, learned advocate for the petitioner, seeks extension of the interim order granted on 17th June. And lastly extended on 30th June 2025. The interim order extended granted on 17 June 2025 and lastly extended 13 June 2025. It extended till the end of August 2025.
Milord, your lordship kindly fixes up a date, Milord. It is tender matter, Milord.
Yes,
Public
but that's also my prayer, my lord. Kindly fix it.
kindly fixes, but tender matter, Milord. Public work is stalled, Milord. For public good, Milord. Kindly fixes up a date.
August ended up until further order, whichever is earlier. Any copy has been served upon the
No,
petition?
order. Affidavit on behalf of the state that we have received, but my lord, affidavit on behalf of the added respondent that is yet to be.
Okay. August এটা 30 শেষ অবধি আছে তো আমরা প্রথমে
কবে
15th
ডেট
August
করছি?
এর পরে
21
date করব under returnable motion না না আগে আগে
কবে করছেন?
যেদিনে হবে 18th 19th এরকম যেদিন হবে
তাহলে accepting 21st.
19th
19th.
learned advocate for the petition is directed to communicate this, intimate the learned advocate for respondent, added respondent intervener of the next date.
Yes.
Kindly intimate him
Yes, sir.
of the next 19th returnable motion top.
Returnable motion at top. Great.
Good.
এই যখন inside কত ছিল লাস্ট নাম্বার end of August আজি অবধি the original site কোথায় oh you are for added respond you did not respond ঠিক আছে Mr. Jahan, it is not required to serve notice because চলে গেল
Yes, yes. Yes, I am here, my lord.
okay added respondent number added intervener is there so no need to serve notice.
Great.
Yes. তাহলে ওখানে সুরিত বাবু ওকে একটা এক্সটেনশন করে দাও the prayer of learned advocate for added respondent intervener, let the affidavit in opposition be filed by the returnable team.
And reply in the meantime, my lord, we shall use.
1 week করে দাও 1 week এর মধ্যে ফাইল করবে 1 week এর মধ্যে রিপ্লাই দেবে 1 week and 1 week.
Yes, yes.
Sure. কোথায় okay original site.
So with your lordships, kindly, may I mention one recalling application in the original site? It is related to
He was a recording the application.
which is the না বলছি with your lordships, kindly, may I mention one recalling application in connection with the letters of administration? The matter was appearing last week also. Now the matter is not appearing. May it be again listed. I'm just handing over the slip to your lordship's officer.
That is not a recalling application, that is a revocation application.
Revocation.
Revocation can be taken up by
No, it is not revocation, it is recalling. The prayer is for recalling. I have checked up, that is why the matter has come up. And it was considered by your lordship.
what considered? I passed an order, you have sought for recalling.
I have not sought, but the other side has prayed for revocation as well as recalling. Since the recalling is there,
Order is passed, suppose and grant is allowed and order is sought for recalling. In this sense, it is a revocation order.
no, my lord. Here, since the word recalling has been used, that is why I mentioned the matter before. Had it been a case of simplicity or revocation, it would have gone to the appropriate
It will go to
jurisdiction.
the court having determination. Because It is not a simply considered as recalling application. Recalling of the order. It's a revocation. To find out, we also আপনি এক কাজ করুন, ওটাকে নিয়ে আমার চেম্বারে একটু দেখাবেন তো, প্রেয়ারটা আছে। We'll see, come in the next week.
Yes,
mention. Let me go through the একবার দেখাবে তো। Yes.
Lord, may I mention item number 9 of your Lordship's original site daily list, Lord? Lord, it is a review application. Lord, it is appearing along with a section 5 application having a delay of around 70 days. Lord, I believe notice they mentioned, we are mentioning upon notice. I believe, Lord, they would certainly pray for an adjournment or an opportunity to file an affidavit. Lord, we are mentioning upon notice if that, Lord, period, my Lord, made, if subject to Lord's kind sanction, Lord, on the last occasion, my Lord, may recollect Mr. Banerjee, Sotto Banerjee, I was not there. He was addressing your Lordship's, Lord. Nobody appeared on the last day. There was also a resolution. Lord, I was most humbly praying if my Lord passes an order for filing of affidavit, the period could be shortened. They would definitely pray this will not prejudice them, and or my Lord, in that case, if my Lord upgrades the matter on any day, whatever, Lord,
it will automatically appear on the next Thursday.
But Lord, it is appearing at the bottom of the list, Lord. We are not, if my Lord be so pleases, Lord, if some precedent could be given, Lord, only that, Lord.
On the next week you mention.
My Lord wants me to mention next week. I'll renew my prayer on next week. Next week. My Lord, I'll wait and renew.
May it please your lordship.
I'm appearing for the petitioner, my lord.
My lord, there are two applications which your lordship was hearing, my lord, together, GA5 and GA6. This really is a mountain made out of a molehill, my lord. GA5 is the application by a caveator who is the GA5, who is the widow of the deceased. My lord, will kindly take my prayers in GA5. My lord, will find it in the master summons, my lord. My first prayer is an order be passed directing Mrs. Roma Sen, who is the applicant for the letter of administration, to serve a copy of PLA number 8 of 2018 to the applicants. Well, till date, I have not been served with the copy of the application. Well, we'll kindly see the prayers in the master summons.
Yes.
But I have not been served with a copy of the application. So that is my first prayer, that please direct a copy to be served. But my second prayer is that I be permitted to lodge caveats. But caveats can be, multiple caveats can be lodged. But my lord, here why I am praying for this, because my lord, initially when I had lodged a caveat, that was only on receipt of the GA, which is an injunction application filed in connection with the main PLA. So my lord, we were served with an injunction application stating that my clients have possession of certain assets and the bank operation of the bank accounts. So there should be an injunction restraining my clients from operating the same. So my lord, that has nothing to do with the main application for grant of probate. That was an interlocutory application filed in connection with, my lord, the PLA application. So my lord, when we come to learn of that application, we immediately file, my lord, an application for, we immediately lodge a caveat. My lord, 2-3 admitted positions, my lord, which is there. A, till date, no citation has been issued on either the widow or the minor daughter. No citation issued. My lord, your lordship's, my lord, department also has a report which has been filed before this honorable court indicating no citations issued. Second is that only the widow, which is Mrs. Shorbori Sen, had lodged a caveat.
Now, the third admitted position is that
Your client.
my client. And the third admitted position is that, my lord, no application has till date been served on the other legal heirs of, my lord, the deceased, which is his widow, which is my client, and also the minor daughter. Now, your lordship, it may so happen that in the application for grant of letter of administration, the applicant may have prayed, I do not know because it has not been served on me, may have prayed that letter of administration may be granted to my client, the widow. I do not know. So if that be the case, I need not file any affidavit in support of caveat. I may be willing to have the grant, but I do not know what is there in the application. So without looking at it, it's impossible for me to file an affidavit in support of that. Well, the reason being, the original side rules also and various judgments of our Honorable Court, my lord, have held that, my lord, the plaint, the application for grant of probate or a letter of administration is treated as the plaint, and affidavit in support of the caveat is treated as a written statement. So, my lord, to what will I file, my lord, a written statement if I ask this question to myself? If the plaint is not served on me, but I cannot deal with any of the arguments. I may choose not to if I find there is nothing to object. But that does not absolve of the liability of the propounder or the applicant herein. Not the hearing, the applicant in the main PLA proceeding to serve a copy of the application. Possibly, they are taking an advantage of a direct provision not being there in the original side rules. But I would try and satisfy your lordship that by necessary inference, if the original side rules mentions that an application has to be served. May I indicate why? If your lordship kindly takes a look at chapter 35 of the original side rules.
Okay. Yes.
Well, will find that both an application for probate and a letter of administration without a will annexed, which is our case, has been treated as par. As in, the provisions and the procedures would be identical. Now, if your lordship kindly takes a look at the rule 1, this talks about non-contentious business. We are not really concerned with that. Kindly comes to your lordship rule 9, which is citation to rightful parties.
Okay.
On an application for letters of administration, unless otherwise ordered, a citation shall issue to all persons having a right to take the grant prior or equal to that of the applicant, unless the persons have signified their consent to the application. So, if there is a consent affidavit, citation need not be. But your lordship would see, the operative words is unless otherwise ordered. But if I may humbly say that this provision or this phrase, unless otherwise ordered, required an order of a court that for XYZ reasons, citation need not be served. Otherwise, in all general case, citation has to be served. Your lordship would see, in our case, citation has not been served. And B, there is no order to the contrary that, my lord, a citation is not required to be served for any reason. There is no such order. My lord, all that is there, your lordship,
Then if a caveat is lodged by a party, then
Yes.
also in that case the citation has to be issued because
my lord, could I take your lordship to that caveat issue in a bit, my lord?
Oh.
In a bit, because that has been what has been sought to be argued, that I had a notice, so citation. But I shall address that point. I have to cross that hurdle, my lord, if it is one. My lord, your lordship would see from provisions of, my lord, rule 9 of this chapter that citation issuance is mandatory if there is no consent. So, my lord, here in our case, my lord, that argument that since a caveat has already been lodged, no requirement to cite, can only at the highest be applicable to, my lord, the widow. But so far as the daughter is concerned, daughter has not been served with any citation. Daughter has not lodged any caveat. So, my lord, the entire procedure has not been followed, at least to the extent of the daughter, who has the 1/3 share in the estate. My lord, now, my lord, the other issue is that, my lord, citations,
yes, continue.
well, as your lordship knows, my lord, citation, I'm sorry,
Yes.
citations, my lord, may be a general citation also, which is like a publication in a newspaper. So, my lord, with citation, there is no automatic service of, my lord, a copy of the probate or a letter of administration application. But it's unlike a summons in a suit. But in a suit, summons, the contents of a summons, my lord, the provisions of the Code of Civil Procedure mentions that the plaint has to be annexed with the served or annexed with the writ of summons. But in the case of probate, there is no such provision that with the citation, the application has to be forwarded. But this is possibly one of the provisions which, my lord, or the lack of which is being sought to be taken advantage of. That that this entire chapter of the original side rules is silent on service of any application on the caveator. Your lordship will not find any provision for that. But, my lord, the provisions are such that it can be read into it. My lord, why I say so? Kindly takes a look at, my lord, Rule 24. Any person intending to oppose the issuance of a grant of probate or letter of administration must either personally or by his advocate acting on the original side file a caveat in the registry. Notice of filing of the caveat shall be given by the registrar to the petitioner or his advocate acting on the original side. So caveat is wrong. Then kindly see 25. Affidavit in support of caveat. Where a caveat is entered after an application has been made. But I shall deal with this aspect in a bit, my lord. After an application has been made for a grant of probate or letter of administration with or without the will annexed, the affidavit or affidavits in support thereof shall be filed within 8 days of the caveat being lodged, notwithstanding the long vacation. Kindly marks the next sentence, your lordship. Such affidavit shall state the right and interest of caveator and the grounds of objection to the application. So, my lord, if the application is not required to be served, my lord, this sentence, in my humble understanding, subject to my lord testing it, of course, would not be there, that the affidavit in support of caveat should contain grounds to oppose the application. So, my lord, service of an application, in my humble understanding, would have to be read into the statute, even if, my lord, the plain language of the statute does not, my lord, contemplate that. Now, the next provision, my lord, which is Rule 26, is, my lord, the notice to caveated to file affidavit. Where an application for grant of probate or letter of administration with or without the will annexed is presented after a caveat has been filed, the registrar shall forthwith issue notice to the caveator. Remember, this is after the caveat is filed. If a probate or letter of administration is filed, so we are not really concerned with this. So, my lord, what the petitioner or the propounder is taking advantage of is, my lord, Rule 25. Because, my lord, it is an admitted position that the date on which the caveat was lodged is after the institution of the application for grant of letter of administration. But, my lord, the difference is in the facts of the case where that caveat was not lodged pursuant to the citations or receipt of the probate application, but receipt of a GA, a general application in injunction application, really, in connection with the probate proceeding. So this provision, they are trying to take undue advantage of by just playing with the date. That, see, my probate was filed prior, caveat is filed thereafter, so they should have filed the affidavit in support of caveat within 8 days of lodging of the caveat. But this really, my lord, would not give them the right to contend that, because, well, it's an admitted position that citations have not been issued and the application has not been served. Well, why? Well, your lordship has seen it umpteen number of times, but just for the sake of completeness of my argument, but kindly takes a look at Rule 28. May I place it, my lord? Upon the affidavit in support of the caveat being filed, notice thereof shall be immediately be given by the caveator to the petitioner. The proceeding shall, by order of a judge, upon application by summons, be renumbered as a suit in which the petitioner for probate or letter of administration shall be the plaintiff and the caveator shall be the defendant. Then kindly marks this. The petition for grant of probate or letter of administration being registered as and deemed a plaint filed against the caveator, and the affidavit filed by the caveator being treated as his written statement. The procedure in such suit shall, as nearly as may be, according to the provisions of the code. So, my lord, if the plaint is not served, your lordship, but there cannot be perhaps, my lord, any question of any written statement being filed. But what they are trying to play with is, my lord, the first sentence or the first portion of Rule 25, which says where a caveat is entered after an application has been made. Well, but the facts would show that this is really, my lord, the date of filing of the application, but the application was never served. And in fact, my lord, in course of submissions, the propounder, the advocate for the propounder has also not contended that they have even attempted to serve the petition. On the contrary, the submission is that it is not required. So, my lord, this, in my humble submission, is perhaps, my lord, not the correct appreciation of law. Now, my lord, two other things, very short, my lord, may I just indicate? But if your lordship kindly takes a look at my affidavit in support of my master summons, my lord, the application. But kindly sees paragraph 2 at page 2. But I have said that on or about second week of January 2018, I had received a copy of an application being GA1 filed by my mother-in-law. Then paragraph 3, no copy of PLA 8 was served on me, in as much as from GA1 I came to learn that Mrs. Romashen had filed an application for obtaining letter of administration to the estate of my deceased husband without any will annexed. On advice of my erstwhile advocates, I had lodged a caveat. Because from the GA, I could see that something has been filed. Then paragraph 4, it remains the fact that no citation was ever served on my daughter. But there has been no answer to this. My daughter on me, and it is only after receipt of GA 120, J number 121 that I had alone lodged the caveat. But it is a fact that to all applications I am contesting, all the GAs, pleadings are complete. So it's not that I am evading any hearing. But I am, even if your lordship says, okay, very well, I'm considering your plea, I file it tomorrow. I still cannot do it because the application has still yet not been served. That is why my prayer is kindly directs serving of the application, and immediately thereafter I shall file the affidavit. Now, your lordship would kindly consider one judgment which my learned friend had placed reliance on. That is the judgment in the case of Nandolal Sheikh. Facts are completely different. So, this is really not applicable. But still, I shall try and place that judgment to contend that that is somewhat in my favor also. In fact, it's espousing some cause which I am trying to persuade your lordship with. But I'm sorry, Mulu.
Just a minute. এটা বন্ধ হয়ে গেছে কেন video? বোর্ড দাও না। না। Yeah.
It's frozen. Rachit, there's an issue with the court system. So my advocate on record who is present in court has sent a text that the court has asked to join after 10 minutes. They're trying to restart the system.
Okay, thank you. Same link, right?
Yes.
Okay, thank you.